Hello, everyone. How are you? Um, this is attorney Ifoma Odunlami. Okay, I just got onto Instagram and I am on Facebook. I'm on YouTube. So, good afternoon, everyone. This is attorney Ifoma Odunlami, immigration attorney from the Odunlami Law Firm in New Jersey. We work at our law firm to help our fellow immigrants so that they can get legal status without fear of deportation. And so today I have a really great topic. So I decided to do this topic because somebody had asked about it at the last live, the last Facebook live, excuse me, the last Facebook live I had last week. So I'm talking about waivers. I'm going to be doing waivers today. I'm going to give you an in-depth knowledge of waivers. So for those who are just joining me, please feel free to say hello when you join. I'm really excited to talk about waivers. I love doing waivers, and it's challenging. It's interesting. It's There's a sense of relief when you put together a good waiver package, and the joy you get when you get a waiver approved is second to none because waivers are discretionary. So, hello everyone. Hi, Instagram. Hi, Facebook. Hi, YouTube. Let's get started. So, first of all, I want to talk about a recent waiver case that we got, and then I'll go into the details of what a waiver is, when do you need a waiver, and I'll give you examples. I don't have a lot of time today because I'm actually supposed to have a court hearing. I'm waiting for the court to call. They haven't yet, so I'm just gonna go ahead and do this live. But if I get someone to the Zoom hearing, I will leave and come back. But let's see if we can get through this really quickly. So, waivers. What is a waiver? A waiver is a forgiveness. That's what it is. So, an intended immigrant may have committed some kind of immigration, uh, you know, crime. I don't want to use crime, but they've broken some immigration law. And so, for them to be able to get their green card, they have to be forgiven for that law that they broke, right? And like I said, it's all civil laws, okay? Nothing criminal here. So, I'm going to talk about a recent waiver case that we got successfully. I'm so excited for this client because the journey was really long. So this client was not our client originally when he filed. He came to us after his waiver had been denied. So I'm going to go through the history of his case and then get into how we filed the waiver and all of that. So this man, I'm going to call him Mr. X, and to protect his privacy. So Mr. X got married to a U.S. citizen a long time ago, and he had hired an attorney to file an I-130 and I-485 petition. They filed this petition in 2009. 2009, that's how long it took him on his immigration journey. So he went for the interview with his wife, and they denied the I-130 was approved because they were able to prove it was a real relationship. But the I-485 was denied, which is the adjustment of status application, which allows him to become a green card holder, was denied because he had committed a series of, I want to call them low-grade crimes, because it wasn't anything he went to jail for. It was that he paid fines, but they were crimes involving moral turpitude, which means they felt that it was some kind of theft, it was a theft of some sort. So he was denied, and his attorney then filed a 601 application for him, and that 601 was denied in 2016. And then he filed an appeal after it was denied, and the appeal was dismissed in 2017. And then he filed a motion requesting to reconsider the denial, and that also was denied in 2018. So this man had a petition starting from 2009, and the marriage was the I-130 was approved. It was a genuine marriage. Nobody was questioning that. The issue was he was applying for waivers to forgive his the law he broke in municipal court, and and they refused. They said he hadn't proven that he was worthy of getting the waiver, right? So they denied him. So the last denial was in 2018, and then he came to our office. I think it was 2020 or maybe 2021. He came to our office, and we reviewed the case. We did a FOIA. We reviewed all the filings, and we didn't think that the 601 waiver application was properly done. We felt that it could have been stronger, and we told him we would refile it for him. So we filed a 601 application to forgive the theft, and it was approved. So think about this. This guy filed the first 601, maybe it was in 2016. It was denied. He appealed it and appealed and motion to they were all denied. Then he came to us. And after reviewing the 601 application, I could see that it could have been done better. And we did a fantastic job, because now this man and his wife, they're older, and they've been at this for a long time. Still married, still happily married, but he cannot get a green card. He cannot get a work permit. It was really stressful for them. So the 601 was approved, and then we got the RFE for the medicals. And like I said before, when you get the RFE for medicals, it could be an indication that USCIS is not going to call you for an interview, and they will just give you the green card. And that's exactly what happened. We got his green card in the mail. One bright day, I walked into the office, and there was his green card. This is a journey he had been going on since 2008, 2009. Can you believe that? So I tell you this to give all of you out there hope who are on your immigration journey. Sometimes it takes longer, but the important thing is you need to go to an attorney who knows what they are doing, because every petition is not going to be there's no right to a waiver approval. It's discretionary. What that means is that you have to make a good case to convince them that you deserve this waiver. So we're going to talk about what situations that you would need a waiver, and what a waiver requires you to prove, what a successful waiver application looks like. So, like I said, if you have committed a crime, criminal convictions, you will need a waiver. And so, like my client here, even though it was not a big deal crime, like he didn't go to jail, but he committed some kind of what the government considered a theft, so he couldn't get his green card. So if you have a criminal conviction, and I'm not talking of traffic tickets, okay? Because I know I'm going to get a slew of calls asking, I got a traffic ticket. No, we're not talking about traffic tickets. In this case, it was a theft. All right. Now, if you have committed any crime, right, that crime may be waivable or it may not be waivable. So that's why you need to talk to an attorney. So a criminal conviction is a reason to get a waiver. Unlawful presence is another reason to get a waiver. Unlawful presence is you're in the United States, your visa has expired, and now you are, here unlawfully without, with an expired visa, right? And I'm going to tell you the people that have unlawful presence, it could be somebody who came in through the border without inspection and is here. That person is going to need a waiver, right? Even if they're married to a U.S. citizen, if you came through the border, you will need a waiver, right? Typically, what we call a 601 waiver, which is a provisional waiver. The waiver gets approved, and then you have to go back to your country and then go for the interview and come in through consular processing. Coming through after the interview. So if you're coming through the border, you're going to need a waiver. if you are here, even if you came with a visa, the visa expired, and you're married to a green card holder, you cannot adjust your status because when you're married to a green card holder, you must be in legal status to be able to adjust your status. So if you're married to a green card holder and you have your visa, you've overstayed, you will need a waiver to be able to adjust your status and and get your green card. Another time you need a waiver is fraud or misrepresentation. This is a big one. So it could be fraud. You committed some kind of fraud, or you misrepresented a fact to USCIS, to CBP, which is Customs and Border Patrol, to the embassy in your country when you were trying to get a visa. If you had any kind of misrepresentation or fraud, or you didn't give them information that you should have given them, you could need a waiver if USCIS requests that. So let me give you examples of misrepresentation. For instance, you're coming to the United States, you want to get a B1, B2 visa, and you tell the officer that you're married when you are not. And you tell them you're married because you're looking to show that you have ties to your country so that they're more likely to give you a visiting visa, believing that you will come back to your own country after you've visited the United States. So you come to the United States, you get married to maybe a US citizen, maybe a green card holder, whatever, you get married. And then somewhere along the line, they say, well, you are married when you went for the interview. That's what you told us. So where's the divorce decree? Now, if you're not really married, you should not have a divorce decree. I'm going to tell you guys that the answer is not to get a fake divorce. Please don't do that. Misrepresentation screw up your case. The answer is to basically fall on your knees and say, I lied, and get a great attorney to file a waiver petition, right? So that's one misrepresentation. Another misrepresentation could be you go to the embassy, you are trying to come here to, you want to go to school, you tell them you're going to go to school, you get an F1 visa, and you come here and you never go to school. You never had any intentions of going to school. Now, this is not always a situation where you need a waiver, right? Because there's some misrepresentation, yes, but sometimes the officers overlook it, So sometimes you may need a waiver for that, sometimes you may not, right? Another misrepresentation is, let's see, you come to the United States, you get married to a US citizen, and you have a divorce decree and from a previous relationship, and USCIS says the divorce decree is it was a fake divorce. And so you're going to need a waiver. You're going to need a forgiveness because you submitted fake documents. And this is such a big problem, guys. I keep talking about it. And the fake divorce decrees are just something that is so unnecessary. Divorce your spouse from the United States, because the fake divorce decree complicates a process that could be easy, So that's that you would need a waiver. Another reason why a fake divorce decree complicates your process is if you are not properly divorced, then USCIS will not recognize the current marriage to the US citizen, and you can get no benefits from it. So there are many different ways, many ways that USCIS or immigration finds misrepresentation, fraud. It could be lying about how many children you have, lying about pertinent information in your immigration application. All of that stuff could send you to, may require you to file a waiver. So there's the different types of waivers. There's 601 waivers, 601A waivers, I-212 waiver. And the waivers, right, you can file a waiver inside the United States. You may also be required to file a waiver when you're doing consular processing. You know, you go for the interview, they deny you until you file a waiver. That could also, you know, be a way to file to get your waiver. Like I said, the waiver is discretionary. There is no right to it. You have to produce a strong case. So for that, we're going to talk about how do you qualify? How do you qualify to get a good waiver? Or how do you present a good waiver application? So a successful waiver application requires you to show that the U.S. citizen or the green card holder, parent, or spouse will suffer extreme hardship if you were not allowed to either stay in the United States or if you are not allowed to come to the United States. So the extreme hardship is on the U.S. citizen, parent, or spouse. It's not on the U.S. Is not on the intended immigrant. And so let me give you a particular scenario where that creates a lot of difficulty for people to get a waiver. Say you came into the country through the border, right? You are not inspected, you are not admitted, you are not paroled in, nothing like that. And then you come in here, you have a child, you live here for 21 years, your child is now 21, your child is a U.S. citizen, your child can file a petition for you. However, you have no qualifying relative. So you don't have a U.S. citizen or green card parent, U.S. citizen or green card parent, or U.S. citizen or green card spouse who is a qualifying relative, because your U.S. citizen child is not a qualifying relative. So in that case, you're really stuck. So the I-130 may be approved to say that this is your child, there is a valid relationship, but you're not going to be able to get a green card because you cannot adjust your status because you do not have a qualifying relative that allows you to file a waiver. And so this is something we see all the time because we have a lot of people who come in, they're really excited because their child have turned 21 and the child is a U.S. citizen, can now file for them. And then we ask them, how did you come into the country? They came in through the border without inspection, without admission. You cannot file a waiver. All right. So now let's talk about, hi, Brian. Hi, Abosade. Hi, Instagram. So let's talk about extreme hardship. How do you show extreme hardship? So top of the line evidence is medical. If you show that your U.S. citizen parent, U.S. citizen or green card holder parent or spouse has some medical condition that will cause extreme hardship for them if you were not allowed to stay in the country, or if you were not allowed to, you know, come into the United States. For instance, you have a family member that has a chronic condition, a chronic sickness, you know, and you're the one who's responsible for taking them to the hospital. You're the one who makes their food. You're the one that takes care of them. That, you know, that is, you know, a really that's a good way to show extreme hardship. So extreme hardship is not is not a regular hardship. It's not, I'm gonna miss my family member hardship. It has to be something substantial. And sometimes it's a combination of different hardships. So sometimes you don't have one good hardship, but the combination of all the little hardships culminates to one great hardship, one to culminate to an extreme hardship. Excuse me, guys. So hardship could also be because when you show hardship, you want to show that the U.S. citizen or green card holder, parent or spouse will suffer extreme hardship if you were not allowed to stay with them in the United States, and they would also suffer extreme hardship if they had to leave United States and come with you to your own country. For instance, one of our clients that we got a 601 waiver approved, we show that the spouse was much older. The country that the intended immigrant came from was a different language. They spoke French. The U.S. citizen spouse did not speak French, would not be able to learn French, would not be able to find a job because they were much older, would not be able to communicate. They had some health issues. They had a doctor that understood their issues. We could show also that if they were to leave and go to another country, the medical facilities in that country were subpar and they would not be able to manage the illness that she had, the spouse had, the American spouse had. So you want to show extreme hardship here in the United States for the U.S. citizen or green card holder um, spouse or parent. You also want to show that they will suffer extreme hardship if they were to follow the intended immigrant back to their country. So a hardship case really is, it depends on the circumstances of the person's of everyone. People have different hardships. So it's important to do a proper interview of the person to figure out what their hardship is. Now, a lot of people have, of course, financial hardship, but financial hardship alone really would not suffice. It's really not good enough. So you want to have, financial hardship can be included, but you want to have other types of hardship. And a lot of times, the one big hardship that usually helps is being able to show that there's a condition that a family member suffers from that will not be well taken care of if the person were to leave the United States. So now, what other hardships are we talking about? It could be a hardship based on the fact that maybe the U.S. citizen spouse or parent is pursuing an education here to better their life, and they won't be able to get the same quality of education if they were to leave and go to another country, or that they would not be able to, maybe they need the spouse as somebody who maybe takes care of the kids, who is responsible for certain things, and they won't be able to do that because the way their schedule is, it's impossible for them to do all of this stuff. Or you can show that both of them are needed because one child has such a chronic condition that one parent could not possibly handle it alone, and the care they're receiving here cannot be gotten anywhere else. So there are many different ways. I'm going to start answering questions soon, but there are many different ways to show extreme hardship. And as part of our the application process, as part of the things we submit, you want to provide evidence. Everything you're talking about, if you're talking about a health issue, you want to provide evidence of the health condition. You want a personal statement, your declaration, talking about your declaration from the family member, the U.S. citizen or green card holder, the declaration from the intended immigrant. Typically we do it as by way of the intended immigrant, explaining this, what happened, apologizing for breaking the laws, and basically going into their story. And then the U.S. citizen green card holder will talk about their hardship that they would suffer. And a lot of times we actually get the assistance of a psychologist, like we do a psychological evaluation, especially if there's mental health issues involved. And we do country conditions, to show, how that country that the intended immigrant is from, how hard it would be for the U.S. citizen or green card holder, spouse or parent to live there. You want to do country conditions to show, that they cannot get a job, that it's a dangerous place. There's no good medical benefit, no good medical facilities, and all that stuff. And then, of course, we culminate all of that with a strong, powerful legal brief. And so, I don't know if anybody has any more questions, but so that's pretty much it for waivers. but you must use an attorney to file a waiver, because it is complex, it is complicated, and like I said, it is discretionary. So the power, whether you get your waiver approved, depends on a large on a large part to the strength of the application that you submit. So I'm going to look at a couple of questions. There's Brian Alvarado who says, can you check your immigration status on the USCIS website if they send a prima facie or an RFP with a receipt number? Brian, you can check your immigration status, but a lot of times it basically gives you the last action. It's not as helpful as it could be for if you're a VAWA petitioner. It basically will tell you that your application was received and all that. If they sent you a green card, a work permit, they'll tell you something was sent to you. If they sent you an RFP, something was sent to you, that kind of stuff. But it's not going to tell you anything like your case is going to be approved soon or anything like that, which is what a lot of people are looking for. And sometimes that status, which you can find on the case, the case status. I think if you Google case status immigration, it will show you that information where you can get it. You put your receipt number and it will give you something, but it's not always updated. But it's always a good idea to check it, because sometimes if they've sent you mail and you haven't received it and you see that it was sent, that will tell you that there's something out there, and allow you to go. Yes. So Brian says that they received his VAWA January 24, 2023. Then that's all it shows. And that's all it's going to show. The VAWA applications don't really give you, anything more than they received your application. Your EAD, the I-485 portion will tell you that your EAD was sent out, that kind of stuff. But it's not in-depth information. So let's see if there's any questions on Instagram. So the thing with Instagram is it's kind of just scrolls by. And it scrolls by really quick. So sometimes you have to go all the way back to get information. So I see a question here from about Abolette. Abolette says, I applied for my wife abroad since August 2022, and the date the USCIS gave to me passed, but the progress show not anymore the date. We are not approved yet. What can we do in the waiting time? Abolette, you applied August 2022. It's about a year. Typically, I-130s are approved within a year. So I think, first of all, check the case processing website to see how long it's taken for where you are, because cases are processed differently depending on where your case is. So check that, and if it's past the processing time and you haven't received anything, I will start off with an inquiry, right? And when nothing happens after the inquiry, you might want to call congressman to see if they can assist. And if nothing happens with that, you may want to file a lawsuit, writ of mandamus. But you want to start off by making sure that the case is not within processing times, okay? All right, so let's see. I'm still checking to see if the court has called my case. All right. So Yolanda says, how would they notify you have received an interview waiver once NVC has finished their part when filing for immigrant spouse of a U.S. citizen? I'm not really sure I understand the question, but I think what you're asking is, how would you be notified that you need a waiver, I think. So once you do the interview, typically the officer there will let you know if you need a waiver. And so you get to apply for a waiver, and then once the waiver is approved, you apply for the waiver typically to USCIS. Once the waiver is approved, you get notification of it, okay? All right. So Lighty Bola says, I'm with an F1 visa. How can I change my status? Well, what status are you changing it to? That's what I want to ask you, Lighty, because just having an F1 visa doesn't entitle you to change your status. You have to, if you have an employer who is filing a work authorization for you, then you can change to an H1. If you are, if a family member has filed, I mean, you have to have something that you're changing your status to. You don't just change your status because you're on F1. So if you're on F1 visa track, you want to be looking for an employer when you get out of school to file for you so that you can get to the next stage, which would be a H1B, an H1B visa. Okay. All right. All right. Let's look. Adakrai says, how long after your green card interview do you wait for before asking for help? It depends. It depends on my clients, really. I've had a client who had an interview March, and this is August. We're filing a writ of mandamus because we haven't heard anything. But there are people who don't want to sue the government because they feel that there will be, consequences. And I'm telling you, there's not. But typically, you should show that you have tried to reach out. You've had your congressman try to assist, and there's just nobody. They haven't responded, and therefore you have no choice but to sue, and then you sue, and you will get a response one way or the other. Whether it's positive or negative, you will get a response. All right. All right. So Hiram says, how can I remove conditions on a 2-year green card when my controlling spouse threatens not to sign the I-751 petition? So Hiram, there are things called waivers. And a waiver is helpful if your spouse is controlling or is abusive, refuses to sign the I-751. You can remove the conditions on your own using a waiver. And if you're going to use a waiver, I'm going to suggest that you use an attorney because the I-751 interviews, they're tough. The officers typically, they will ask a lot of questions, and if you're somebody who suffered abuse, it can be really hard. So you want to make sure that you're able to prove that it was a bona fide marriage, right? You always want to show that it was a real marriage, and then you want to show that there was abuse, and that's why you have to do it on your own. So if you want us to assist you with that, give us a call 973-993-1900. We do a lot of I-751 waivers. And so Habib says, what does a beneficiary do if the spouse dies before the interview? So Habib, you need to notify USCIS that the spouse has died, and they will convert your I-130 case to an I-360 case. You will still be called for an interview, and when you go for the interview, you still have to show that it was a bona fide relationship, it was a real marriage, and you have to provide evidence of that. Okay? All right, guys, I'm going to run because it's 3:41, and I just want to make sure that I'm ready for my court hearing. So if you have any questions or you have suggestions of of any topic that you would like me to talk about, I am happy to discuss it. Just put the information on this. I come to check this later on, and we can go from there. But otherwise, I hope you guys have a great day. And like I said, if you need a waiver, if you've committed some kind of immigration offense, don't think that there's no way to proceed to get a green card. The one thing you don't want to do is to complicate it by, trying to cover up, because that's now several levels of fraud or misrepresentation. And if you have committed some kind of crime in the past, you want to talk to a lawyer to see if a waiver would be something that would assist you to get your green card. Okay, so take care, guys, and if you need our assistance, 973-993-1900. We assist clients from all over the 50 states of the United States. Have a great day.